Assalamualaikum and hi everyone, we are from Group 1 and we will be presenting the defense of mistake.
Assalamualaikum and hi, my name is Maisara Anissa binti Muhammad Rahimi. My metric number is 291340.
Assalamualaikum and a very good morning. Okay, my name is Horul Ain Azakiah binti Sharifuddin and my metric number is 291219.
So okay guys, my name is Nur Huda binti Sulaiman and my matrix number is 291271.
My name is Wan Nur Ain Batrisha binti Wan Abdul Halim and my matrix number is 291286.
Assalamualaikum and hi, my name is Nurul Shami binti Imran with the matrix number 291201.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurin Arvin Aisyah binti Hazmi Rudansham. My matric number is 291251.
So, what is defense of mistake? Basically, defense of mistake is where an individual asserts that their actions were a result of an honest mistake and therefore they should be excused in terms of legal liability. And defense of mistake can be categorized into two, which is mistake of law and mistake of fact.
So let's move on to the provisions in the Penal Code where there is a fourth section, and I'm going to explain about Section 76 and Section 79 of Penal Code. So, Section 76 of Penal Code state that act done by a person bound or by mistake of fact believing himself bound by law. Nothing is an offense which is done by a person who is or who, by reason of a mistake of fact and not by reason of a mistake of law, in good faith believe himself to be bound by law to do it. So, it is mean Section 76 of Penal Code refers to a factual error and emphasizes that, in good faith and with due care and attention, individuals must really believe that they are bound by the law for this provision to apply, particularly to authorized persons. Meanwhile, in Section 79 of Penal Code state that act done by a person justified or by mistake of fact believing himself justified by law. Nothing is an offense which is done by any person who is justified by law, or who by reason of a mistake of fact and not by reason of a mistake of law in good faith believe himself to be justified by law in doing it. So, this means Section 79 of Penal Code deals with factual errors, requiring persons to behave in good faith and honestly believe that they are justified by law. And this section applies to the general public.
Okay, I'll be explaining about the provisions of defense of mistake on the Penal Code. Okay, the first one is Section 77, which states that no crime is committed by judge while acting judicially in the exercise of any power granted to him by law, or that he believes to be such. Next is Section 78, which states that it is forbidden to do action in adherence with or justified by court judgment or order while the judgment or order is still in effect, even if the court lacks of authority to issue the judgment or order. So, it is true that so long as the person acting in good faith thought that the court had the authority to issue the order.
What exactly is a legal mistake? Mistake of law is a legal notion that refers to one or more errors committed by a person in comprehending how the applicable law applied, where a mistake typically refers to the failure to recognize the presence or otherwise of a given law that is important to a certain situation. There is a principle of law that is ignorantia legis neminem excusat, which means that ignorance of law is not an excuse. In criminal cases, a mistake of law is not a recognized defense, though such a mistake may in very rare instance fall under a legal category which is exculpation or proof someone is not guilty of wrongdoing. In criminal cases, a mistake of fact is normally called simply as mistakes. So, I'm going to give an example for the mistake of law. It is the case of public prosecutor versus Koh Chiu Ye, where, in this case, the Session Court of Penang convicted the accused for importing 6 pianos from South Africa, which there is a statutory ban of the importing goods from South Africa. the defendant appealed to the High Court, then the High Court acquitted the defendant from being charged with the reason of unintended mind to commit the crime. In other words, no guilty mind of it. The Federal Court stated that proof of lack of knowledge on the balance of probability that the goods in question were prohibited from importation may be ground for acquittal as a fact of mistake. However, lack of knowledge of the prohibition as a matter of law may not be admissible as a defense even it is provided with sufficient evidence unless the accused can prove on the balance of probability that he could not reasonably have known of the prohibition. Federal Court stated that any lack of knowledge to the ban as to the law prohibiting shall not be an excuse even if it is backed up with sufficient evidence. So moving to the next, mistake of fact.
Assalamualaikum and hi, my name is Nurul Shamim with the matrix number 291201, and I will be explaining about the mistake of fact and a case example of the defense of mistake of fact. So mistake of fact usually involves when an incorrect mental state, idea, or conviction brought on by ignorance, misbelief, or misunderstanding of the facts that leads to a wrongful act or omission committed by one or both parties to the transaction. However, it has to be that without the transactions being fundamentally wrong or being known or intended at the moment. So simply put, a mistake in facts occurs when someone unintentionally forgets or is ignorant of a fact, whether it be current or historical. It must also be a legitimate mistake with no malicious intent. Continuing with the case example, I will be referring to the case of Chirangi versus State of Nagpur. In this case, Chirangi mistakenly killed his son, thinking he was a tiger due to a bilateral cataract and a leg abscess causing temporary delirium. The court held that Chirangi, in good faith, believed he was attacking a tiger, not his son, and he had no intention to commit such offense. Chirangi at the moment truly believed he had a valid reason to kill what he saw to be a dangerous wild animal. Hence, under section 79 of the Penal Code, he was protected in light of the circumstances and his mental state.
So, to analyze the defense of mistake, we believe that basically it is a concept that acknowledges that individuals, they may make errors in judgment or understanding a situation, and in result they should not be held fully accountable for their actions. So this defense also recognizes that culpability often depends on intent, and if a person genuinely believes that their actions were legal or lack criminal intent due to a reasonable mistake they have made, either by mistake of law or mistake of fact, then they may be excused for legal liability.